Hello, my name's Wahyu Ningsih. I'm a partner in Nusantara DFDL Partnership. I've been practicing for 16 plus years. My areas of practice is employment, regulatory and compliance, foreign direct investment, and also merger and acquisition.
I think it's because when foreign investors entering the Indonesian market, they tend to focus on three main big things, like market entry strategy, tax structuring, or even business licensing. And because of this, somehow employment affairs kind of translated into matters that can be sorted out later. While in actuality, as an employer, your legal obligations already started, not even when you start hiring, but when you start your recruitment processes. Because Indonesia, I think it's something that we need to emphasize, is very protective towards employees, especially local employees. And second thing that I need to highlight is that I see there are some misperception, I would say, in the market where, upon the issuance of Omnibus Law, some investors think that employment regulatory interpretation is become more significantly flexible or relaxed, which is untrue, because yes, there are some procedures that are being streamlined, but the core protection itself remains very strong, specifically when it comes to salary components, when it comes to employment termination, and severance packages. There are 3 or 4 major points that every employer, despite foreign investors or domestic companies, needs to take a note and understand. The first point would be the type of the employment contract. There are 2 types in Indonesia. First is the permanent, second is the non-permanent. So permanent contract basically, for employees without employment period limitations. And having said that, the government, through the regulations, provides some sort of relaxation for the employer before they commit, such a long-term commitment hiring this particular employee. So through a permanent employment contract, the employer can apply 3 months probation period. Unlike permanent employment contract, this probation period is not existing in the non-permanent employment contract. So non-permanent employment contract specifically designated for type of works that are temporary in nature. And that's why there are limitation in terms of the employment period, which if we can total, the entire period would be maximum 5 years. So that's the first point. The second point would be the minimum wage. So every region in Indonesia sets their own minimum wage amount that is updated on an annual basis. So employer, they must not pay their employees, whether permanent or non-permanent employees, below the minimum wage. Second would be termination and severance. So in Indonesia, we're very protective towards our employees. So you cannot terminate without cause. And when you terminate an employee, they are entitled to severance package. The amount would be depending on the type of employment contract that they have. But in any case scenario, it's not that easy to fire or to terminate an employee in Indonesia. So I think it's something that needs to be understood by every employers when they want to enter Indonesian market. Fourth would be outsourcing. I think there are some misunderstanding in the market that outsourcing is not available in Indonesia. It does available with some sort of limitations. I think the employer needs to understand that when you hire a vendor outsourcing company, the employees are not yours. So the employees are the employees of the vendor of the outsourcing company. So you need to make sure when you're structuring your service arrangement with the outsourcing company, you want to eliminate any chance or any kind of clauses that can be interpreted and can create an assumption that the outsourcing employees is your employee. I can think of 3 main points: process, cost, and culture. Process, it's not easy to commit employment termination in Indonesia. The process are strictly regulated. The timeline is regulated. There are extensive procedures. Not to mention if there's some sort of objection from the employees, it needs to be settled before the termination can be finalized. And therefore, the process itself can take very long time. Aside from that, the second would be the cost, right? The cost, again, severance package is mandatory in Indonesia. Whether you are a permanent or non-permanent employee, you'll be entitled to some sort of severance packages. The amount, the formula might be different between the permanent and non-permanent employee, but in any scenario, you'll be the employee. When I say you, I mean the employee would be entitled to some sort of a payment, whether through multipliers, which applies specifically for a permanent employee, or some sort of compensation packages when it comes to non-permanent employees. Third, I think this is a bit sensitive because we're talking about culture. Employment affairs is I think it's a social dimension in Indonesia. So when it comes to employment disputes, particularly when it comes to employment relationship, more often than not, I would always advise my client that you need to handle them delicately and respectfully. Otherwise, everything can escalate very quickly. I mean, when you heard a sentiment of local employees, they tend to go to, we're just gonna go to the court. And it's not about getting the compensation that they want. Sometimes the ego plays a part. So I would say to the client, when you want to handle HR affairs, employment affairs, employment termination, you need to take into the culture. You need to take culture into the consideration, and yes, make sure you handle it delicately to avoid any unexpected outcome. Short answer is no. It will not be easy, and obviously it will not be quickly. As I mentioned before, employment termination in Indonesia is regulated, and it requires certain procedures, requires certain documentations, notification, and timeline. So for instance, if you have a manager that is poor in performance, you cannot just fire him on the basis that, well, I gave him verbal warnings already. Because in Indonesia, warning, it has to be made in writing. It has to have validity period that is prescribed and has to have legal grounds. You need to have documentations, and in practice, you need to be able to prove that you already gave him some sort of a chance for improvement. And you need to have this documented properly. So in case it's escalated to a dispute resolution in industrial court, you will have enough legal basis to stand your ground. Otherwise, you will have weak case, which may result in you need to pay the maximum amount of severance package that is allowed under the law, and I don't think anyone wants that. So there are 4 main gaps that I often found in the field. The first will be the non-compliance of employment contract. So Indonesian labor laws and regulations already prescribe the minimum clauses that mandatory to be provided under employment contract. If you miss some or one of the clauses, it can effectively affecting your employment relationship. For instance, if you have a non-permanent employees and you're hiring them under a non-permanent employment contract, but you miss some clauses, this employee can claim that, well, your employment contract is not enforceable, so by the end of the day, I'm actually a permanent employee. And we don't want that, right? Second, it would be the underpayment of overtime money. So again, Indonesia has regulated about the formula on how to calculate overtime money. The formula sometimes are correctly used, but things can become an issue when the salary component is consisting not only basic salary, but also fixed allowance. Because I often found that employers tend to disqualify or excluding this fixed allowance component when they want to calculate the overtime money. And because of that, it's resulting in the underpayment. Third gap, I would say the overuse of non-permanent employment contracts. So again, as I mentioned, the maximum total period the employer can utilize non-permanent employment contract is 5 years. But unfortunately, in practice, I've found many employers that hiring, that engaging employees in Indonesia for more than 10, even 12, 15 years, but still through non-permanent employment contracts. Of course, this is illegal, and once you found there's such issue, it will continue to another different 10 issues like the social security registration and so on. The number 4 gap will be the non-existent of company regulation. So in Indonesia, when you are hiring or you're employing 10 employees or more, you must have what we call company regulations. It's basically employee handbook, where some things that are not fully regulated under the employment contract, it needs to be stipulated in the company regulations. It also needs to be registered and legalized by the Labor Office. Otherwise, as an employer, the company may be subjected to several sanctions, including administrative sanction and criminal sanction. I think there are 3 main points. 2 would be from the regulatory perspective, and another one would be from my personal opinion, if I may. The first point would be the HR should expect some sort of refinement when it comes to technical regulations, specifically upon the issuance of Omnibus Law. Even though, yes, we have a string and very lengthy regulations that are already covering employment affairs, but still, when you actually enter into the field, you can find that there are certain gaps that needs refinement and needs a further technical regulations, such as even though this is a very common subject, employment termination, outsourcing, even the severance itself. Second point from the regulatory perspective, I would say data protection, because in this era, not only in Indonesia, I think it's international wise, everything is digitalized. Employment documents, governmental submission applications, everything is conducted online. And Indonesia is also very protective when it comes to data protection. So even when you're collecting information from your employee, they are still going to be considered as a data subject. So you will need their consent as mandated by the regulation. So I think aside from the HR knowledge, HR employees or HR officials within a company needs to also have a proper knowledge and management towards data privacy. The third, it will be, again, this is my personal opinion, but I think the culture of the current employees are quite significantly different to the employees back in 10 years ago. Right now, younger employees, they are more literate when it comes to their legal rights. They have access to legal laws, they have access to legal jurisprudence. So I think they are more aware of their legal rights. Having said that, they might be more focal when it comes to the enforcement of their rights. So I think there will be a trend where HR complaints and HR disputes might be heard by HR officials or HR officers in the company. So again, I think we discussed this earlier, that it has to be handled delicately and respectfully. So HR, they need to understand the culture, and they should not see this proactive attitude of the younger generation as a attack. But it's just part of the process where the world starts evolving, and I think we're also as a older generation need to adapt because it's a good sign.